International law. Visualized. What are the sources of international law? The term source of law refer to legal rules governing the international community. Unlike national laws, where sources of law are specified in the Constitution which is superior to laws and regulations, no such hierarchy exists in international law. The International Court of Justice stipulated a catalogue of sources of international law, which is used when deciding legal disputes submitted before the World Court. The first source is international treaty, whether a general or particular convention, a bilateral, regional or multinational one. A treaty is a binding international agreement, by which the states parties agree in writing, to observe their contractual obligations. The second source is customary law, as evidence of a general state's practice accepted as law. At the outset, international law was mainly regulated by customs, which is an unwritten rule, and consists of two parts, state's practice, and opinio juris. State practice is the material part of customary law, and it combines states' behavior and actions. In other words, it means what states do and say. Opinio juris is the second part of customary law, and it means that the state's verbal or material acts have to be accepted as a binding law by the rest of the international community. For instance, the world accepts and believes that it's legal for a state to act in a self-defense. In addition to treaties and customs, other sources of law exist, like the judicial decisions of international courts, juristic writings, which represent the teachings of the most highly qualified publicists, and lastly, the general principles of law, recognized by civilized nations. While these are not formal sources, they can still play an important